Thank you, Mr Deputy President. I would like to ask the Minister for Policy and Reform why the Safeguarding Act 2018 is coming into force without subordinate regulation.
The Minister for Policy and Reform to reply.
Thank you very much, Mr Deputy President. I'm grateful to Tynwald members for their valuable feedback in respect to the subordinate legislation and guidance for safeguarding, which was provided in response to the public consultation, at the members' briefing in January, and subsequently via correspondence and through a number of discussions with me directly. In order for the regulations to reflect a number of the important points raised by members, it has been necessary to allow an appropriate amount of time for redrafting and then discussion of that redrafted version. Consequently, whilst the appointed day order, which brings the Safeguarding Act 2018 into effect from 1st of March 2019, was laid before the January 2019 sitting of Tynwald, subordinate legislation which supports the Act will be submitted to the March 2019 sitting of Tynwald and will come into operation with immediate effect, subject to approval, of course. Whilst there is no statutory requirement to make regulations under the Act, it is considered desirable to create an appropriate statutory framework which provides the procedures to be adopted for the Safeguarding Board, the Action and Implementation Panel and the Serious Case Management Review Panel to discharge their functions and deliver their objectives, all of which are established by the Act.
Supplementary question, Mr Hooper.
Thank you, Mr Deputy President. I wonder if the Minister remembers when he brought this Act through the House of Keys. He made a very clear commitment at second reading, at clauses and at third reading. I'll read that commitment out to the Tynwald Court just for clarity. He stated, "I wish to emphasise that the Act and the regulations are a legislative package, and as such the provisions within the Act will not commence without a network of subordinate legislation which will support it." The clear promise was made to the House of Keys when he brought that bill through. It would appear that's not the case. It would appear that the regulations are now coming before March, Tynwald, and the Minister is hoping that they are not also riddled with holes and problems like the last set of regulations were, and that Tynwald will approve them straight away. My question for the Minister is, the appointed day order itself actually doesn't bring in the child death overview panel. It specifically excludes that. So we are now going to have a section of the Act being brought into force, or not being brought into force at all, rather, primarily, I suspect, because the subordinate regulations weren't ready and didn't properly address them. So is there no need for the CDOP to be placed on a statutory footing? Will this be addressed in regulations in March? Will the new appointed day order be coming forward? Or was the Minister intended to make a complete hash of this as well?
Minister to reply.
Thank you very much, Mr Deputy President. It is really quite disappointing that the great brain that the Honourable Member for Ramsey has is then camouflaged with language which isn't quite correct. So there's not, the regulations weren't riddled with errors and holes. It's not a complete hash. All that it is that when the Safeguarding Act was taken through in February, March 2018, the intention at that time on advice was to include the child death overview panel inside the safeguarding regime. Since then, there have been changes, new people involved, new review of the situation, and it's now not the intention to have the child death overview panel inside the safeguarding regime, but inside the public health regime, as it is in most local authorities around these islands. In other words, most children who die tragically, in no sense is their death caused by safeguarding issues, it's other issues, and so therefore it makes more sense to try and understand that child death in a public health context. I might have said, Will, I haven't reviewed my notes, but it's clear that Section 9 of the Safeguarding Act from memory talks about may establish regulations. I just remind the Honourable Member that the way that safeguarding has come in has taken 12, 15 years, far too long. It goes back right to some very unfortunate incidents that happened all of that time ago. What's happened is over a number of years we've made incremental steps, and for a number of years we've had safeguarding, a children's safeguarding board and an adult safeguarding board extra statutorily outside statute working to do good things, to arrive in the place where we've now got in statute one safeguarding board across the piece. What we're talking about here is 18 days, I think it is, where we won't have the regulations that weren't in any case riddled with holes. We've now had a really good dialogue, cross-government, and outside government as well, working out the best arrangement. And if people want to make comments about that in March would be the time. But I really do hope that the regulations that were ready for the February Tynwald weren't put on February Tynwald because we wanted to make sure and have a further dialogue to make sure they were absolutely suitable for purpose. And that's what's happened in the last few weeks. And I stand by my position, and I will stand by my position, and we're in an awful lot better place with a statutory safeguarding board across the piece with perfect regulations rather than ones that were drafted a year or so ago but have now been informed by valuable member comments and valuable outside Tynwald and legal comments as well. Thank you very much, Mr Deputy President.
Supplementary question, Ms Edge.
Thank you, Mr Deputy President. Can I just ask the Minister, he's just stated there that he may consider that the death of a child will be dealt with by the Department of Health and Social Care. I'm just concerned under my understanding of safeguarding is the independence of the safeguarding board, and is there not a conflict if an investigation is carried out by a department who will have had possible dealings with a child that has come to these unfortunate, this unfortunate event? Can the Minister just clarify that? Because I'm concerned there would be a major conflict there.
Minister to reply.
Obviously, thank you, Mr Deputy President. Obviously, I'll circulate information if I need to, and from a legal point of view. But any death can also have a safeguarding element as well as not having a safeguarding element. What I said was that most deaths will just be public health issues and will be dealt with in the context of learning lessons to avoid similar issues in the future. Of course, any death of a child can have a safeguarding aspect and would be the subject of the independent safeguarding law and under the independent review of the safeguarding board.
Supplementary question, Mr Hooper.
Thank you very much, Mr Speaker. Just to clarify something the Minister said, he said the regulations weren't brought before Tynwald. They were brought before Tynwald. They were withdrawn before any debate could happen because the Minister knew that they weren't good enough. My question to the Minister is, he brought an Act through the House of Keys at which there were 3 of these subcommittees, the Child Death Overview Panel being one of them, and it was made very clear to us that it was necessary to place these on a statutory footing. That debate went through the duly elected lower house of Tynwald. It went through the duly elected upper branch of Tynwald. And now all of a sudden the Minister is saying he's completely changed his mind as to what the law needs to deliver. When was he planning on telling either branch of Tynwald that his intentions had changed, that the needs had changed? When is he going to share with us the reasons behind all of this change? It doesn't seem to make a lot of sense to bring an act, to bring a law through that whole process, and after going through the whole process decide, actually, I've changed my mind about this little bit, and I'm going to do this without any form of public debate or consultation whatsoever.
Minister to reply.
Thank you, Mr Deputy President. Here's me thinking that the 31-year-old Laurie Hooper would become a much more mature and sensible fellow when he became 32.
Order. Mr Deputy President, I think we just need to answer the question.
Thank you, Mr Deputy President. Yeah, a small change to the Safeguarding Act would be a logical outcome of the discussions that have now taken place across government with the third sector, with experience from cases in the Isle of Man, and it's quite likely that we will amend the Safeguarding Act in coming years with a suitable bill inside the government's legislative programme. As I said to you, we had a chair of safeguarding, independent chair of safeguarding, who left office at the end of March 2018. We've got a new chair of safeguarding board. We've got public health that's been making great progress in establishing that office and that work stream. And surely the honourable member for Ramsey would agree that better law is what we're all after. And I say the regulations that were there in January weren't riddled with holes and errors. There was just one simple basic change that we needed to do, which is in respect to the Child Death Over panel, and that change has been made.
Final supplementary on this question, Mr Hooper.
Thank you, Mr Deputy President. The Minister didn't actually answer my question. Obviously, something has changed since he originally brought this Act through. Things must have changed because they've changed his intentions. My question was, when was he planning on telling people that his intentions had changed, that the outcomes had changed, that the Act itself isn't going to be delivered in the way that it was presented to us in 2018?
Minister to reply.
Thank you, Mr Deputy President. Any time I've been asked in the Tynwald Court, I would have told, as I've done today, and it's been our intention. I think it's fully explained in the explanatory memorandum that's been laid before, that will be laid before March Tynwald. There's nothing mysterious about this. We've worked through properly a change in policy about where the child death overview panel is going to be located. The way to do that was to change the appointed day order, and the appointed day order that tells the story is already on this Tynwald order paper. So the original appointed day order has been amended to withdraw the 1st of March application to the child death overview panel. That's clear. I've already told people if they knew where to look inside that. And what I've said today is that at some point, using one of the pieces of legislation that's coming forward, we can make a small change to the safeguarding bill. The Attorney General has got this concept of a statute law revision bill. I'm not sure whether that small change would be beyond the realms of that. Otherwise, we can find some sort of social policy bill that can be used.